Hey everybody, my name is Jeff Fowler. I'm with the Apartment Owners Association of California. It is really, really good to have you with us today. Great topic. We have two attorneys. One is an owner attorney, the other is a resident manager attorney. And so they're going to go at it, and you're going to learn a whole lot about owner or resident manager law. So this is going to be a great time that we have together. And before we get into it, I just wanted to give some updates for you. And first of all, AOA is really here to help you become more successful with your investment property. So what we want to do every time that we come to you, we want to give you an idea that'll help you either save more money or make more money. So the whole thing is your success. And so because of that, we're one of the largest associations here in the state. And we're just so happy to serve you. And one thing that I've been talking to a lot of new members, and one of the things that has kind of surprised me is that many of them don't realize that you can actually call in and get help with the forms and figure out what your rights are. We'll help you do that. And when it's complicated, we can refer you on to an attorney. And anyway, so I just want you to know that if you're a member. If you're not a member and you're out there and you're looking for a life raft, AOA is probably a good place for you to get some solid forms. And speaking of forms, I don't have it on me, but there is the one new form update that we have for this week is there's a 10-day notice in San Francisco. So if you're in San Francisco, there's a new 10-day notice that you have to give before you can even give the standard notices. So anyway, wanted you to know about that one. Next week, we're going to have Dennis Block with us. And so he's going to go over LA County, the eviction moratorium, what you can and can't do. And this is happening right before Housing is Key program closes the application. So this is really important for you to know. Okay, April 1st, what's the new phase that we're going into? What are my rights? So you'll definitely want to be a part of that. And then after that, we have somebody from Housing is Key, Nancy Blivens, I believe, and she's going to come and just give an update about what has happened and what's possible in the future there. So those two are next week. You'll definitely want to tune in. The second one, it's really statewide, and so it'll be good for everybody to tune in on that. And also, if you would like closed captions, please go to Facebook. And you can watch this and all of our live streams live. You can get the closed caption live there. And of course, if you're watching YouTube after the fact, it'll have the closed captions as well. And then also I do want to give you an update. We do have this lawsuit against LA County for the eviction moratorium that they extended, and now they've termed it tenant protections. And so we have a hearing that's set for April 6th, and that is LA Superior Court. And so things are moving forward there, and we're hoping to get an injunction and stop the eviction ban. And again, if you're tuning in for the first time on that, it's the due process of law that we believe is being stepped on. Your rights are being stepped on there because after Housing is Key is gone, there's no third party that can tell you whether this person really has a COVID hardship or not. And so when they're self-certifying, it's clearly unconstitutional. So we're going after that one. There's already cases in the city of LA, notably the one with Palmer, the $20 million lawsuit, and then San Francisco as well. In Oakland, there's lawsuits. And so hopefully these things will work through the courts and we'll be able to restore our property rights. And so these are things really, it'd be great if you donated to those. We have the Political Action Fund. So please donate, and that's aoausa.com/political action, and you can donate there. If everybody chips in, then hopefully we'll get there. And also, after we have this interaction, there will be time for Q&A. And so just be thinking and writing down your questions, and then when we get to the Q&A, you can post those questions and we can get going. And also just want to say that our sponsor today is Parker Milliken, and personally, I am one of their clients. We have property management software, and we are about to go live with a rent payment history service. And so they put together the consent forms for that. And so literally they do work for us, and they're here in LA. They've been around for almost 110 years now, which is crazy. And it's a mid-sized firm, but yet they deliver kind of like a big firm would, but you don't get the price tag that a big firm would have. And so they're here, and they do lots of different things, and you'll hear more from them. And anyway, so I'm going to let Andrea introduce the two speakers, and she'll take it from here.
Thank you, Jeff.
Yeah.
Hi, I'm Andrea Oguntula, and I'm attorney at the firm of Parker and Milliken, and I'm actually going to be the moderator of today's webinar. First, I would love to introduce our two panelists for today. First, we have Mr. Arie Ebrahimian. Arie is one of E&L LLP's founders and managing attorneys. As an employment attorney, Arie represents employees in matters involving wrongful termination, harassment, discrimination, and whistleblower retaliation. Arie has also handled numerous wage and hour cases, many involving property resident managers before the court and labor commissioner's office. Welcome, Arie.
Thank you.
Our second panelist is actually my boss, Mr. Gary Ganchrow. Gary is the head of the litigation department of the firm of Parker and Milliken, a 108-year-old downtown Los Angeles full-service law firm. Gary has asked me to let everyone know that he has personally not been at the firm that long. Gary is also a former professor of law at USC Law School. Okay. And as part of his employment and litigation practice, Gary represents numerous property owners and property management companies. And a significant part of his practice involves writing resident manager employment agreements, advising clients that may have got into sticky situations with resident managers, and defending lawsuits and labor commissioner claims brought by resident managers. Gary is a frequent writer for AOA Magazine and lecturer on resident manager topics. Welcome, Gary.
Thank you for the introduction. We should be able to tell by the introduction who's wearing the white hat here this morning and who's wearing the dark hat, but what, you go ahead.
Very true. So our format, it's going to be very simple today. I'm going to be asking these two very knowledgeable attorneys questions about lawsuits and claims by resident managers and other resident manager issues. The goal is so you can hear from two different perspectives. One from a lawyer who actually represents resident managers who feel they have been wronged, and then the other from a lawyer who defends these claims. The lawyers can also ask each other questions, so hopefully you'll leave today's webinar with a better understanding of these claims, and if you're an owner and employer, how to avoid them. So let's just go ahead and jump right in. I'm going to start with our plaintiff's lawyer, Arie. Arie, so this one is a two-parter. How do resident managers even find you?
Thank you. Thank you for AOA for allowing me to be part of this very important platform to discuss a very important subject about resident managers. We live in a state that most people are renting, so then there's a need for property managers, resident managers. So oftentimes that results in employment law cases, and that's why we're here today. How my clients find me is we've been fortunate that we find most of our clients through referrals. Other attorneys refer cases to us. The client may initially go to a defense attorney like Gary, who practices mostly defense work, and our colleagues would essentially refer that client to us for a case evaluation. We do some online marketing, but most of our clients come through referrals.
Okay, that's a good thing. If most of your clients are coming through referrals, that's definitely a good thing. In your experience, what are the main reasons an on-site manager goes to see a lawyer about a possible claim?
One of the main things is they believe that they were not paid for all hours worked. So most of these resident managers cases are wage and hour cases where a resident manager comes in and says, look, I work X number of hours per week. I'm not being paid for all my hours. So most of it is wage and hour, but we also get a handful of prospective clients that inquire about Work-related injuries, which is kind of outside the scope of my practice. So we refer them to a workers' compensation attorney for a case evaluation. Some of the prospective clients we get come in and they say, look, I've been there for a decade or 2 decades, and all of a sudden they terminated my employment without an explanation. So that often raises a red flag of why this person was abruptly terminated after many years of service. So forces us to look into the case further to see if there's a possibility for, disability discrimination, age discrimination. Perhaps the prospective client engaged in some sort of protected activity where they complain about health and safety code violations, and that resulted in their termination. So most of the clients that come in are inquiring about unpaid wages, but we have a handful of clients that come in for wrongful termination matters, work-related injuries. So we get a mix type of cases, but most of it is wage and hour.
Thank you, Arie.
Yeah.
Thank you.
Yeah.
Gary, same question to you. So in your experience, what's the reason or the main reasons an on-site manager will go and see an attorney about a possible claim or lawsuit?
Okay, before I answer that, I also want to thank AOA for putting this on.
Yeah.
It is often frustrating for me when I get claims or people contact me about representing them, and it's after the fact and things are already messed up, that I couldn't get the message out before they messed up to enough people. And this is a good forum, an excellent forum to help us do that. I'm gonna disagree with Arie a little bit, probably not for the first time today. Having done this and talked to as many people as I've talked to on the owner side and on the property manager side, then dealing with plaintiff lawyers like Arie and then indirectly with their clients, I think usually what happens, yes, it is about owed wages. Ultimately, it's about money owed, I agree. But usually something happens to trigger it, right? Usually the most managers don't go to see lawyers unless they feel threatened, either by something that the owner or the employer said, or they feel like they're not being appreciated, or they get angry at something, and they could be, what they're angry about could be real, could be legitimate. I've seen cases where it's completely in their own head. But nonetheless, something sets them off. And then they get angry, or they feel like, oh no, they're gonna fire me, they're gonna kick me out of my apartment where I've been living for 20 years, they're gonna take away my job, this building is my baby. But it's emotional. It's often not just about the money. Then the lawyers get involved, then it becomes about the money, perhaps, but initially it's not. So that answer might surprise people, but there's often a very emotional component to it, and one that I find I have a hard time sometimes getting my client, the owner or the management company, to appreciate the emotional component that's on, that probably exists on the other side. Beyond that, anytime there's a change in circumstances, it could trigger a manager going to see a plaintiff's lawyer. By change in circumstances, I mean obviously a termination. If the owner or the management company is threatening to take away someone's job, that will often, if it's not done right, sometimes even if it is done right, will often send someone running to a plaintiff's lawyer like Arie. But any kind, and that's why, we'll talk about this a little bit more, I think, later, but that's why you got to do things right on the front end, because otherwise, anytime you want to change the manager's circumstances, and if you haven't been paying them right, you're kind of in a vulnerable situation, and you're at risk. They're going to run to a lawyer, and now all of a sudden you're kind of in the soup, and you're dealing with people like Arie and claims. So it's often emotional, it's often a change in circumstances, and then, of course, there's just the, hey, I'm owed money. Arie said you get most of your cases by referrals, but there certainly are lawyers who advertise in this area, specifically in the resident manager area, and I'm not encouraging anyone to do this, but if you would go online and do a search for plaintiffs' lawyers doing resident manager work, you're going to find them pretty easily. So I think it's all of those triggers. It's often a combination of those triggers, but there is a much larger emotional component to this than I think is often given credit for.
I agree, and oftentimes you can nip it in the bud if you see a particular issue with a resident manager. talk to them, figure out what's bothering them, because oftentimes, and I agree with Gary, oftentimes my clients come in and they're like, look, I have no meaningful talks with the owner. You know, I try to engage them about certain issues at work, and they're not responsive. They're not receptive to my needs, and I think that's a trigger. That, you know, if they're not getting their questions answered through the employer, what are they going to do? They're going to run to a lawyer. So nip it in the bud if you can, as an owner. If you see that the resident manager is having some issues, has some questions, talk to them, engage them. Figure out a possible solution to the problem without it unnecessarily escalating to a point where they go to an attorney. And I'm not that type of attorney. I'm not trigger happy. I don't file a lawsuit right away. But some attorneys do it. As soon as they send up the case, they file the damn thing, and you know, a problem that could have got resolved by just informal discussions ends up in litigation where both parties are now committed to a lot of time and resources unnecessarily oftentimes.
And the one thing I know for sure is there is always, 100% of the time, going to be a dichotomy between the value of the work that the resident manager is giving in the resident manager's eyes and the value of that work in the owner's eyes. There is always, I think it's largely often undervalued on the owner side, and it is often overvalued on the resident manager side. And that leads to, they don't realize how important I am in managing and keeping this building afloat. And that often leads to hard feelings, which I find is often a trigger. So a lot of it is, people managing as much as it is all the technical legal stuff that we'll probably talk about.
Going off of that, when you speak to these clients, when you're evaluating your claim, what's the most important question that you typically ask? Arie, we could start with you.
There's not just one question. You know, we ask a number of questions. You know, length of employment, how long they've been working there for, are they treated as an employee or independent contractor? That's a big issue in this state where employers improperly classify workers as an independent contractor to avoid paying them proper wages. One of the primary inquiries is, are they being paid for all hours worked? And Gary touched on this. A lot of the clients come in exaggerating their hours, and then sometimes the owners don't really fully appreciate the true hours that these people are really working. So the standard for hours worked, and this is one of the biggest inquiries on my end, because most of the resident managers that come in for a wage and hour case evaluation is hours worked. Hours worked for resident managers is the time that they spend carrying out their assigned duties, not time that they spend on call. So oftentimes, and I'm sure Gary gets this all the time, a resident manager comes in and says, "Oh, I'm always available to the residents of the building. I'm always sitting around making myself available, and they don't pay me for that time." And I explain to them, I go, "Look, that's not how it works. You're only entitled to compensation for time you spent actually carrying your responsibilities as a resident manager." So that's one thing that we look into when we're screening a case. I don't know if you have an input as for the hours.
I'm going to talk about that, yeah. But go ahead,
another thing that we look into when we're evaluating a case is, how is this employee paid? Is this employee paid by check or by cash? Is this employee given a wage statement? Because in California, when you pay an employee's wages, you have to also provide them with an earnings statement that has about 9 categories. The name of the employee, how many hours he worked, net wages earned, gross wages earned, if they're working overtime hours, the overtime hours need to be reflected in the earnings statement. So we look into that as well when we're evaluating a prospective client's case. We also ask the client about whether they have records of their hours of employment, because that's really relevant to a wage and hour case. Because oftentimes, and again, Gary touched on this, an employee comes in and says, "Oh, I work," some of my prospective clients come in and say, "I work 60 hours a week." And then we ask them, "Okay, well, 60 hours a week, you need to justify it. How many units are in this building that you're managing?" They're like, "Oh, 10." and I'm like, it's impossible for you to justify these hours. So why don't you explain to me what you actually do? Well, I collect rent. I go, okay, that's once a month. What else do you do? I deposit the rent and I buy materials for the building, cleaning supplies for the building. I'm like, okay, do you have records of those hours? And they're like, no. But end of the day, folks, the burden is on the employer to maintain records.
That's right.
So, but you know, so we again, I at least at my office, we're not trigger happy. We don't just file a case for the sake of filing a case. We do our homework as well before we pursue a course of action for a client. So, or if you have anything to add to that.
No, I want to know how it's possible we got the one reasonable plaintiff's lawyer on our panel. Because those are not the plaintiff's lawyers I'm used. They are trigger happy and they'll file at the drop of a hat. Yeah. It's time. To me, it's time records. It's all about time records. If there's one thing I could implore people to do right, owners on my side of the table to do right, keep time records. If you, as Arie alluded to, I mean, let me go back a step. Number one, very basic here, but if you have a resident manager and you're an owner or you're a management company, you're the employer and they're the employee. You have an employer-employee relationship, and I think a lot of people don't realize that. What that means is there's a thick book, and it's called the Labor Code in California. I meant to bring a copy so you could see how thick it was, and I forgot. But all of that labor code applies to you if you're an employer. So those rules apply. And one of those rules is, as Arie alluded to, you've got to have time records. That means if you have an employee, they have to keep a log of when they clocked in the morning, when they clocked out, if they took a meal break, when they clocked in and out for the meal break. And it's as he said, it's your burden as the employer to have those records. Well, guess what? If you don't have those records, it is a license for the employee to lie, steal, and cheat. And what I mean by that is, by law...
Harsh words.
Yeah, well, I don't mean it maybe quite that harshly, but almost. If you don't have those records, then when you go to court or in front of a labor commissioner, because this person is claiming you owe them money, as Arie said, the burden is going to be on you to show they didn't work those hours. It's not going to be on them to show they did work the hours. They just get to walk into court and say, yeah, I worked 60 hours a week collecting rent. And you have to disprove it. So what happens is, when the way that plays out is clients come, so we can prove they didn't work that many hours. Okay, how are you going to do that? Well, we're going to... we have cameras at the building. Well, the cameras at the building aren't really going to prove it. We're going to talk to all the tenants. We're going to, okay, that's a good idea. We can take their deposition if it becomes a lawsuit. But if you run the math...
It costs a lot of money.
It costs a lot of money to start talking to all the tenants and taking depositions if you're in a lawsuit. And quite frankly, if you're the owner and you've gone that far, you've already lost, right? You've lost, because now you're paying your own lawyer to do all these things. If you lose it all, you're going to end up, and we'll talk about this, but you're going to end up paying the other side's attorney's fees. I'll talk about that more a little bit. So you've already lost. So, you know, what's the expression? An ounce of prevention is worth a pound of
Cure.
Cure, thank you. That's the expression.
And regarding time, the employees' hours, sometimes you could justify the hours. For instance, I've had clients that were not only resident managers, but they're doing a lot of construction for the property owner. The property owner is like, okay, I want you to tear this wall down and go get dry wood and fix it, and go and redo the kitchen and go redo the bathroom. And this guy, my client, was going back and forth to and from Home Depot, purchasing materials, coming in, and he's upgrading all these units. So I was able to add a case, I think maybe it was against you, Gary, that we were able to somehow justify the client's hours of employment by showing receipts of materials that the client purchased.
I don't think you have ever had any cases with me where you were able to justify the hours. I remember that.
Absolutely. The buzzwords are reasonable estimate. We don't have to be on point. So I think in order to provide a prospective client with a meaningful discussion before signing up the case, you want to inquire about their duties. What are they doing? Can they really justify these hours based on what they're doing. Because oftentimes, like Gary said, the records don't exist.
But to me, it's all about the records.
It's all about the
If
records.
a client comes in and sees me, and my first question is, do you have time? I know the answer 90% of the time
Yeah.
before I ask the question.
Yeah.
But did you keep time records? And if the answer is no, you've got problems. If a claim is made, you've got problems. You could be 100% right in everything you're telling me that this guy really only worked 10 hours a week.
Yeah.
It won't matter. It's going to cost you money to get rid of this thing because you don't have the records. And
100%.
it's really hard to get people to understand that and appreciate that. A lot of time I draft contracts for people. We put in the contract, you have to keep, for the manager, the resident manager has to keep time records. And it's if I do say so myself, it's a great contract. But it's only as good as the follow through. And so,
Yeah.
the contract can say you keep records all you want. And if the owner doesn't follow through and make sure there are records, then we don't have records. And it's not going to matter much that the contract says you, resident manager, are obligated to keep records. I mean, we can point to that. It's
Right.
not going to do any good in court at the end of the day when the resident manager comes forward and says, I worked 60 hours a week. I have a matter now in front of the labor commissioner where if you believe the resident manager, they worked nonstop, 9+ hours every day without any breaks. That may or may not be credible, but the problem is to prove that it's not true is costly, as we said. So to me, that's the number one. And then, then I'm going to ask about all the other records. Do you have a written agreement with them? How did you pay them, etc. But to me, the number one thing is time records. And it's, I've said this, I've said it in writing. It is literally a square peg in a round hole. It's not like a secretary who comes in and she clocks in and then she clocks out for meal breaks and she's on the clock the whole time. We all understand a resident manager sometimes is on, sometimes is off. Sometimes they're meeting vendors, sometimes they're getting tenant calls, sometimes they're dealing with rent. And so it really is a start, stop. And everyone understands that. Everyone in this area understands that. But unfortunately, the law doesn't really recognize that. It's a square peg in a round hole, and it's still your responsibility to the best you can to make sure that they record those starts and stops and accurately record their time. So that would be my answer to my long-winded answer to your question.
Thank you, Arie. I mean, resident manager work is very unique. I completely agree from what I've seen. So Arie, let's shift back to you. If you do decide to take a case by a resident manager, do you usually file the lawsuit right away, or do you first try to contact the management company?
That's a good question. Thank you. No, I don't file a lawsuit right away. We at my office, we do our due diligence before we fully commit to a case. And one of the tools at our disposal is that we, pursuant to California law, the labor code allows us to obtain informally, without the need to file a lawsuit, our client's records. So if I send out a letter of representation, I'm entitled to my client's personnel file, documents that he or she signed relating to obtaining and holding employment with the employer. I'm also entitled to any documentation concerning any performance issues. I'm also entitled to payroll records, not time records, but earnings statements. I'm entitled to that. Why do we ask for this information? Because we want to make sure first, most importantly, we want to make sure our clients are being honest to us. If the client is saying, I've had no performance issues whatsoever, and we obtain a copy of the personnel file, we see performance issues, ongoing performance issues, we can call the client out and say, look, you just told us during the consultation last month that you had no performance issues. There's no justification behind the termination, and look at what I have in front of me. I'll give you a perfect example. I was sharing this with Gary not too long ago. I had a resident manager come to my office, a man in his 60s. He said he was a resident manager for 22 years. And he said all of a sudden the employer fired him. I said, well, did the employer say anything before the termination? He says, yeah, they made comments about my age. They said I should consider retirement. So I'm setting things in motion for a potential age discrimination complaint. But I said, let me get a copy of your personnel file before we take that course of action. I said, did the employer say anything else? He goes, yeah, they said they saw me on camera doing something, but they didn't elaborate. To me, that raised a red flag. So I sent out a letter of representation. The letter went to a reputable defense firm, and the defense attorney called me and said, look, did you know your client engaged in theft, and that's why he was terminated? I said, prove it. They sent me the images of the client going into a tenant's unit stealing earpods, brand new in the box, and then I called the client in, and he admitted that he engaged in theft. So why is that beneficial to me? Before I put my name on, contrary to what Gary said, there are honorable plaintiffs' counsel out there that we don't necessarily just file the cases for the sake of filing
I didn't
cases.
say they weren't. I just said you were the only one.
It relieved me from having to draft the lawsuit, file the lawsuit, litigate the case. And this is all, again, time-consuming, very costly, and it puts my reputation on the line. So before I fully commit to a case, to the extent that I can, I try to obtain the records. But now, the problem I encounter oftentimes, probably I would say 6 out of 10 times, some of these employers, they'll call and say, pound sand, I'm not going to give you the records. To me, that raises a red flag that they're trying to hide something. Then I'll just take whatever course of action I was going to take. But I think, folks, as soon as you get those letters from the lawyers, call someone like Gary, who can properly screen the case for potential issues. So again, you can nip it in the bud. If he sees an issue, you can say, look, I'm seeing an issue here. Try to work out your differences with this employee or former employee before it escalates any further. So we do send out the letters before we take any course of action. Only time we'll file is if they don't respond to our letter.
But going off of that now, Gary, so let's say that a client gets a letter from a plaintiff lawyer on behalf of the client's resident manager, and the letter threatens a legal claim or demands money to avoid a lawsuit. So what's your first step in those scenarios?
So, I mean, it's not dissimilar to what Arie just described. I need to get my hands around the facts. I mean, that's number one. So my first question, as I said before, is do you have time records? But do you have any records? Arie talked about making a records demand for a personnel file. And, a lot of times people are going, what personnel file,
Yeah,
what
exactly.
records, what wage statements, because especially with a mom and pop smaller owner, they're just not running it that formally. Again, not really realizing, gosh, this is an employee relationship, and I should be, running this tightly. People aren't doing that; they're not aware. So I need to get my hands around the facts. Are there records? How did you pay this person? Did you pay them with a check every month? Did you pay them using a rent credit? Did you pay them with some combination of a rent credit? If you paid them with a rent credit, how do the numbers all shake down? As I think a lot of people are familiar, there are pretty complicated rules in California about paying with a rent credit. You need a written agreement to do it. So do you have a written agreement? That'll be another question I'll ask. Let me see the written agreement. Who drafted the written agreement? That's often helpful for me. If I hear Dale Alberstone drafted the written agreement, I'm good. Otherwise I may not be. Who's the plaintiff's lawyer? That's actually important to me. And the approach I take may depend on the plaintiff's lawyer. If it's someone like Arie, I got to take the claim seriously, and I'm being serious here. If it's another firm that I know just does a volume business, and they're after a quick buck, and they're not really going to get into the merits, and they probably don't really know this area of law that well, then I may take a different approach and try to settle it quick, cheap, and bluff my way through it. So it's really going to depend on who's on the other side. But the number one thing is I've got to get my hands around the facts and figure out what the story is. And the flip side of what you said is I need the complete picture. If a client comes and gives me half the story, they're not doing themselves any services, or they give me half the documents. That's not really helping me.
100%.
Now, Arie, back to you. So how do you value these cases for settlement purposes?
Gary just touched on something a few seconds ago about the size of the employer. Obviously, if we're dealing with a sterling company, you know that collection is not going to be an issue. They can probably finance a settlement or lawsuit. So we look at the size of the employer. If this is a small establishment, one building with 5 units, and these are the only assets the employer has, we're gonna aggressively try to nip it in the bud by contacting the employer. And if the case is assigned to an attorney, I will call the attorney and say, look, these are the issues. Without the need to file a lawsuit and unnecessarily litigate this case, let's try to work out a settlement. So we always use that as an option. But some of the bigger employers, they have attorneys. They may even have in-house counsel who knows a few things about wage and hour, and they insist on litigating it. And so be it, we litigate it. But it just based on the needs of the client, how long the client has been working there. That's another thing that I also look into. If it's a short-term employment, like 6 months, sometimes it's not worth litigating it. But if the employee's been there for many, many years, then it kind of increases the value of the case, particularly if there are wages involved.
Talk about how far back you can go. I think people would want to.
So, right. So, in California, folks, you have a resident manager has 2 forums that he or she can go to pursue a wage claim, for instance. The Labor Commissioner's Office that we often utilize because it's an administrative agency, the cost of litigation are non-existent before the Labor Commissioner's Office. So if we file the case with the Labor Commissioner's Office, there's a 3-year statute of limitation. Meaning what that means is that the resident manager can only pursue claims dating back 3 years. If they've been there for 20 years, it's not like they can go and pursue unpaid wages for 20 years. They're only limited to 3 years before the Labor Commissioner's Office, which is an administrative body. The case is eventually assigned to a hearing officer, and you go into an informal setting and you basically present your case, and the hearing officer, which is not a judge, renders a decision. So that's the first option. The second option is filing a lawsuit with the Superior Court, where you can go back 4 years. And that additional year can really result in a difference in how we assess the case, because it can result in the case being valued considerably higher. I know it's only 1 year, but it makes a big difference. So we on the smaller cases, we utilize the Labor Commissioner's Office because we don't want to exert too much pressure on the property owner. But on the bigger cases where we know that collection is not going to be an issue, and the cases are strong, the case is strong, has merit, and the client is, on the face of things, is seen as being credible, then we file it at the Superior Court and litigate the cases. So that's how we value the cases.
Gary, same question. How do you value these same cases for the defense side, for settlement purposes, et cetera?
It's very hard if there are no records. Because if there are no, and by records, I mean time records. If there are no time records, and I've got a resident manager who's claiming to have worked an exorbitant number of hours, it's hard to value that case because you don't know how credible that claim is going to be. And I've also had situations where I do have time records, and the resident manager will come in and say, forget those time records, they're not accurate. I really worked 3 times the number of hours that are reflected in the time records. And obviously that's also hard to value because on the one hand, I want to stick them to the time records. On the other hand, I've got this claim which may or may not be believed, ultimately, even though I have time records where they say, well, they made me put down that, right? That's something I hear all the time. The employer told me I had to put down these hours, or they told me I couldn't exceed a certain number of hours, and I had to only put down a certain number of hours on my time records. And you know what? Sometimes that's true, and sometimes it's not true. So, how is a judge or someone or labor or a hearing officer, how are they going to evaluate that claim? I don't know. It's hard to know. So it's hard to value the case. I will say this though, a common question I get, I've had clients say to me, I hear these cases always settle for $30,000. That was as a quote from a client. So well, it's really not that simple, right? It really kind of depends on the facts of the case. I settled cases for a lot less. I've settled cases for a lot more. But what people need to realize is the numbers mount up pretty quickly because the claims that we're typically going to see are, you didn't pay me the minimum wage. You didn't pay me for overtime that I worked. Sometimes we'll see claims like you didn't give me my meal break and my rest break. Honestly, I don't take those too seriously with a resident manager because typically they make their own schedule, they make their own hours.
I agree.
And so I kind of blow that off and don't typically value those. But when someone says you didn't pay me my minimum wages, if that claim is believed, what that means is there's a liquidated damages that the labor code allows that person to collect. So it's not just the wages you owe them, it's twice the wages you owe
Double
them.
penalties.
And if they're owed overtime, well, that's obviously not at the regular rate of pay, that's at the overtime rate of pay. And so those numbers can get up pretty fast, and then if you didn't pay them properly, then probably if the relationship is over, as it usually is, the employment relationship, you owe them money when they left, and there's something called waiting time penalties. You're going to owe those as well. And then here's the real kicker, and here's what, in my opinion, drives all these things. It's the attorney's fees. Because if you're found, I'm sure Arie doesn't think like this, but most plaintiffs' lawyers are, and look, I do the same in their boat, what's in it for me? And they've got to get their money out of it. So, and the labor code allows the plaintiff's lawyer to recover his fees if he can establish that minimum wages weren't paid, or if he can establish that overtime wasn't paid. So you can have someone coming in and claiming, you owe me 1,000 hours of overtime. And I can defend that case, to the teeth and prove that we didn't owe your client 1,000 hours of overtime. We only owe them 10 hours of overtime. Well, guess what? I still lost the case. And he's still going to get his fees. He may or may not, depending on the judge, get all of his fees, but he's still going to get his fees. And guess who pays those fees? My client. So my client is looking at a situation where they're paying me to defend the case. That's the good part. They're paying Arie's at the end of the day because they haven't won the case. And I got to tell you, 99% of the cases I get where a lawyer has made some kind of claim or made some kind of records demand, we're going to lose the case. And we may not lose it to the extent the plaintiff is claiming. The numbers may be exaggerated, but we're going to lose because we don't have records. There's going to be the law is so complicated, folks. It's just so hard to comply with everything. We're going to lose something technical if we don't settle it. And so it's a terrible position for a defense lawyer to be in. It's a terrible position for a property owner to be in. It's like, I treated this person really well. I did 95% of the things right, but I'm still going to lose the case, and I'm still going to owe fees. So you're looking at paying my fees, you're looking at paying the plaintiff's lawyer's fees, and you're looking at owing something to the plaintiff. So how do you value that on the front end? It's hard. It's hard to value on the front end, and we run all the numbers and we run the computations, and I'll tell the client, okay, if they get everything they want, their case is worth this. If they get very little of what they want, their case is worth this. But how much are the fees going to be? That's always hard to tell. How heavily do you want me to litigate this? And and as I said, it's a tough position to be in because it's a catch-22. The more I litigate to save the client money, to show that your client's claims are ridiculously exaggerated, the more I am spending and costing my client in fees, the more you're spending and costing my client in fees ultimately. And so it's really a catch-22. So the goal typically is to try, unless we're 100% right, which is rare, the goal typically is to try to settle it early and inexpensively if you can. Obviously, that's not always doable.
Yeah, and the added risk of unnecessarily litigating a case. Let's assume resident manager's claims have merit and the employer does not maintain any records. What I've seen happen oftentimes is if it's a big employer, guess what? There are going to be other resident managers who are going to learn about the claim or the lawsuit, and they're going to come forward. So the objective is, like Gary said, to try to settle it if possible in the early stages, because once you settle the case, you're going to get a confidentiality clause in the settlement agreement, a non-disparagement clause in the settlement agreement to protect you from having to answer to other potential lawsuits. Because
let me ask you a question about that, because we talk about confidentiality agreements all the time.
Yeah.
And what Arie's referring to is, as he said, in the settlement agreement, if you settle the case, you put in a confidentiality provision that says that the plaintiff, your client, can't discuss the settlement or the terms of the settlement, and
or the dollar amount.
Or the dollar amount. And the idea is so that other employees won't learn about it and seek, a similar opportunity. On my side of the table, we're always pretty skeptical. I mean, we can put that in the agreement, and we do. Sometimes we put in penalty provisions if they violate it. We don't call it that. But does that really prevent employees from talking to each other? Or do you not even know? Because once you're done with the case, you're done with it.
So I always engage my clients in a very, my clients respect the confidentiality provision because I put fear in them. I said, look, they are cutting out a check to you at this stage with the understanding that you keep your mouth shut. Because if you don't, they're going to come and sue you for X number of dollars. And in the 12 years that I've been practicing, I've never seen an issue where the employer is coming back and saying, hey, your client violated the provisions. He went and told other employees about the settlement and the dollar amount. So we're going to go after your client for the penalties. It's not a penalty, but it is a penalty. So I've had great success with it, but I think it all has to do with plaintiff's counsel. Are they going to really engage their client, educate them about the settlement agreement and the consequences of breaching that particular provision? So I think it's effective, especially when they see the dollar amount that in the event of a breach, they're going to potentially get sued and have to pay attorney's fees. I think they respect it. End of the day, I think both sides want closure. I think once the thing is signed and a check is issued to the plaintiff, people go part ways, and it's you don't hear from them ever again. That's from my experience, but some attorneys may tackle that issue differently. But I one of the most important provisions for me when I evaluate a settlement agreement with a client is the release provision and the confidentiality clause, because they're the most relevant, I think, to the settlement agreement.
Thank you, Arie.
Yeah.
So Gary, what are some of the biggest mistakes that you've seen owners or resident property manager? I'll start all over. Gary, what are some of the biggest mistakes you've seen that owners or management companies make when you get these cases?
Everything.
Yeah. I'm not sure where to start with that. I think number one, and I know I'm repeating myself a little bit, is not recognizing the formality of the relationship that they have with the resident manager. I mean, a lot of times there is a friendship. A lot of times the resident manager has been there longer than the owner. Owner bought the building, the resident manager was there. They could have a 20-year relationship. They consider themselves buddy-buddy. And so number one, you have to recognize the format that it is as I said before, an employer-employee relationship. And while everything is good until it's not. And people have a hard time. And look, I don't want this to come off as the only time I ever get any cases or deal with this area of the law is when there are problems and we got a demand letter from someone like Arie. That's not true. I mean, I deal with it on the front end where someone will come to me and say, hey, I need a resident manager agreement. Can you help me draft an employment agreement? Those are my favorite, because then I know I can head off problems, or at least do a lot to head off problems. Sometimes I get situations where someone recognizes they need an agreement, but the reason they recognize it is because the manager already started rocking the boat, or the manager has said something suggesting maybe they're seeing a lawyer or they're going to see a lawyer, and now all of a sudden they want to clean things up. That's always dicey. And sometimes I get cases where I get situations someone wants advice because John, who's been with the manager for 20 years, is getting older, can't do the job anymore, or John is having problems with the tenants, or all kinds of legitimate reasons why you might want to switch managers. But I have to, and so they come to me, how do I do it? And again, I have to get my hands around it and say, tell me about John, tell me about the relationship, and by the way, tell me before we terminate John, did he recently become injured? Did he recently file a workers' comp claim? How old is John? All these questions, because there are lawyers and who will make discrimination type or retaliation type claims, and I don't want to walk a client into that without knowing the facts. I haven't gotten to answer your question yet, but this is kind of all by way of introduction. So I see these situations in all different phases, and then including the problem phase when there's already some kind of claim or lawsuit. And the problems all stem from, I shouldn't say all, many of them stem from not recognizing the nature of the relationship, that this is a legal relationship and legal formalities need to be kept, including time records, including wage statements. And by the way, wage statements apply even if you're paying someone only with a rent credit, even if you're not paying them a check each month or twice a month as you're required to, and they're just getting free rent, you still technically have to give them wage statements as if you're paying them, because you are paying them. You're just paying them with a rent credit. So that's a problem I see often. Not having records is a problem I see often. And again, like I started this presentation, a lot of the problems I see are just the way people are being treated and the way things are being handled. There's a right way to treat a resident manager. There's a wrong way. And quite frankly, it is in your self-interest to do it the right way, because the last thing you want to do is have them run to a lawyer needlessly. I had a boss one time who used to say, be sincere, especially when you don't mean it. And so I'm not suggesting that approach, but there is some truth to that here, which is even if you're not feeling the love for that resident manager, sometimes you want to show it because it's going to go a long way. So that's not a very technical answer to your question, but it really is the genesis of a lot of the issues I see. The technical stuff is, we can talk about. If a client comes in my office, we'll talk about the technical stuff. How do you pay him? How do you set up the agreement? And, how do you collect the time records? How do you report? All that stuff. But to me, that's the cart before the horse, really.
Okay, Arie, I'll pose this one to you. Do you ever make wrongful termination or discrimination claims on behalf of any of your resident managers? And if so, what are the facts that would make you decide to take that kind of claim?
One of the primary inquiries is the size of the employer, because when you're dealing with our discrimination laws, without getting too technical, you have to have, particularly with discrimination, you have to have at least 5 employees working for the particular employer before those protections kick in. So size of the employer is a relevant inquiry. The client's length of employment is also important, because if my client or prospective client has been with this employer for 10 or 20 years, that without any performance issues, that client is going to score brownie points with me, because that's going to suggest that something happened unlawfully that resulted in the termination. Keep in mind, folks, California is an at-will employment state. You can get rid of an employee for any reason or no reason at all. You don't have to have, you don't need to give an employee an explanation as to when or why you're terminating his or her employment, but you can't terminate an employee's employment unlawfully. So we should make that distinction. Just because you have a right to terminate a resident manager's employment, it can be unlawfully. So length of employment, track record with the employer, those are the type of things we look for. The size of the employer is relevant when we're evaluating these type of wrongful termination cases. Those are the main things. And again, before we take that course of action, we do want to access the resident manager's personnel file to see what's in there. Because again, if he or she's coming in and saying, look, I had a work-related injury a year ago, I'm having back pain, I'm regularly going to the doctor, and this is becoming an inconvenience for my employer, and that's why I believe the employer fired me. We want to get a copy of the personnel file to see if there's ongoing performance issues, and that's why they terminated the resident manager's position, not because he or she sustained a work-related injury and was going to the doctor for treatment.
Okay, Gary, off of that, so what's your strategy in defending these types of claims?
As I said before, timing and appearances matter. And a client, and gosh, sometimes clients' timing is just horrible. And it's all about optics. It's all about, you can have a perfectly legitimate reason for wanting to terminate your resident manager, but the optics matter. And if that resident manager recently was injured, if that resident manager recently took some kind of medical leave, if the resident manager is in some kind of legally protected class, we want to look really long and hard at that before, if I'm advising, before we do anything, before we terminate. and if it's already happened, in evaluating the case. I had a case that that just got resolved, where the personnel file had everything in it that Arie just suggested. It had a history of performance problems by this resident manager, but when they actually pulled the plug on the resident manager, happened to be shortly after the resident manager had been threatened and felt their safety was threatened by a tenant. And then they pulled the plug on the resident manager. So the optics matter, and we were told by objective third parties, this looks terrible. I looked at it and said, what's wrong? There was a history of performance issues. Clearly that wasn't the reason they terminated.
Yeah, but why did they terminate him at that point?
That's right, that's the question. Well, why did you terminate at that point? So the optics matter, and so I want to get my hands, how do I defend them? I want to get my hands around all of the circumstances, and that's often where it's pulling teeth from clients, because they don't, and it's not necessarily malicious. Clients don't necessarily realize what's important to tell you. So you got to probe. You got to learn everything you can that might bear on the issue of not was this person wrongfully terminated, but might some juror, sitting in a trial, or some judge think that this person might have been wrongfully terminated. Those are two very, very different questions. It's not about unfortunately, it's not always about what actually happened. It's about what someone might think happened, and they don't know the inside scoop. And so the timing matter and the optics matter. And gosh, I don't even remember what your question was anymore. What was your question?
I think you've kind of laid it out a little bit, your strategy in defending the claims. You've kind of talked about what the thought process and what goes into it, but do you have a strategy you can share with us?
Do I have a strategy? Yeah, settle, win the case or settle cheaply. I mean, it's obviously it's going to be fact specific. And there are cases like the one I just mentioned that looked good to me, but apparently wasn't as clean in the eyes of a third party, and we resolved it because you don't want to take the risk, and the cost is so high to defend these things. And obviously, when you defend them, you don't know who's going to win, and you may win, you may lose, but it's going to cost a client a whole bunch of money to get there. So obviously, if it's something that it makes sense to resolve at the right number, you try to do that. And if you can, and if it's defensible, and the client wants you to defend it, and sometimes clients, or say, let's roll the dice, I did nothing wrong, then you do what litigators do, and you do all your discovery, and you take depositions, and you defend it.
Just to add to what Gary just said, this is, I guess, towards the bigger employers. If you do have a system in place where we call it a progressive discipline policy, which is a fancy way of saying if you have a system in place where you're on paper have a policy where you're required to document performance issues, then utilize it. Don't pick and choose, because I see this happen all the time with employers. They have the policy in effect, but they don't apply it consistently. They only apply it to that particular employee who's pregnant now, or that particular client who's been complaining about health and safety issues at work. So apply your policies consistently. So once there's a lawsuit pending and I do discovery, I'm going to say identify all resident managers who collected rent late. And then they identify 5 resident managers. And I only see that only my client was disciplined for this particular performance issues. To me, that raises a red flag of why is this particular resident manager being targeted? And then, that helps me further evaluate the case. So apply your policies consistently. Don't pick and choose. Don't necessarily apply because a particular employee has told you that he or she intends on talking to a lawyer or filing for workers' comp or take a medical leave of absence. Be consistent, even with the good employees. Be consistent.
Let me piggyback off that. One of my favorite sayings in this area is no good deed goes unpunished. And what I see a lot of times is an owner or a management company that has resident managers will see problems with the resident manager, but they'll look the other way. They'll try to work with them. A lot of times, as I said, owners and resident managers, if it's more of a mom and pop kind of place, they develop a friendly relationship, and so they'll do the resident manager favors. Maybe they'll pay them off the books. Maybe the resident manager doesn't want certain income reported because they're getting benefits. I see that a lot. They're right? They're getting income-based benefits, so they don't want to show the income, and the owner will work with them. And that's all, besides the legality of it, that's all well and good. But it becomes a problem when all of a sudden now there's a claim being made and the relationship isn't so good. Or getting back to our timing issue, if you're carrying the resident manager and you, within reason, obviously you want to do that. But if it's not working out, pull the plug.
Yeah.
Pull it before the timing, before the timing doesn't allow you to pull the plug cleanly, because I see that a lot. It's, I want to get rid of this person, I want to get rid of this person, but by the time they see me, the lawyer, now it's a problem because the person has made some kind of health and safety complaint, so that it's going to look retaliatory when they do it. Or the person just went out on medical leave, or just became injured, or just made a workers' comp claim, and now all of a sudden, even though that really isn't what the owner is thinking, the timing looks horrible. And now my advice is going to be, you know what, don't pull the plug now unless you want a legal claim. Or do it at your own risk, because there's a pretty decent chance you're going to get a claim back. If you would have done it 6 months ago, you would have been fine. But now that you've waited too long. So it's kind of the no good deed goes unpunished. If you see it's not working out, sometimes the best thing to do is to end the relationship while you can cleanly end the relationship. Don't wait for a point in time where it's going to be a legal problem if you do end it.
I think that is excellent advice from what I've seen, working on the few cases that I have in employment. That is excellent advice from Gary. Arie, everything you said, I completely agree. Just a few questions to wrap up. Arie, you've already addressed the fact that you do sometimes decide not to take a case, right? Mm-hmm. Just give us a few reasons as to why, in those particular instances, you don't take those cases.
No names, please.
Yes, no names.
He's a professional.
No.
Look, going back to the case where I had obtained the client's personnel file and I realized that he was terminated for theft. Some of my colleagues on the plaintiff's bar would have still taken that case.
No.
Because of the years, because of the years of employment. This guy was there for 22 years. They're like, we can probably milk this and obtain some sort of a settlement. I don't, because it's a personal decision, because this is a small community and I don't want to have a bad reputation that I'm the type of attorney that takes on any cases, because I know down the line I'm going to have more cases against Gary's office and he'll vouch for me and say, look, this is an honorable attorney. I take what he says seriously, and I think he mentioned that earlier. So you score, and there's a flip side to that coin. When I see that he's not unnecessarily litigating a case, because as a defense attorney, he may have the incentive to push the envelope because they're billing.
Yeah.
But when I see that he's settling the case in the early stages, that signals to me that I have a fair and reasonable partner on the other side who's willing to look at the facts, make concessions, and wrap it up. So my reputation is important. And also another reason why we don't want to, we decline representation is you have to finance these lawsuits. You have to file the lawsuit. You have to take depositions, get experts, motion practice. There's so many costs associated with a lawsuit. I'm not going to put my name on a piece of paper that's not only going to affect my reputation and standing in the community, but also put me in a place where I'm financing a case that's going to end up nowhere end of the day. So that's one of the primary things I look into when I decline representation. Also, we also again have to look at the size of the employer as well. Regardless of how strong the claims are, what are you going to do? You're going to file a claim against an 80-year-old woman who has just this one particular investment and bankrupt her, potentially put her in bankruptcy. So we decline representation in those type of cases as well. But I don't know.
I need to find those 80-year-old women, yeah.
That is good to know that you do decline. You have discretion.
Absolutely.
And I think with being a plaintiff's attorney, you get to have that discretion, which is nice. So we do too, but to a lesser extent sometimes. So I'm going to wrap it up with you, Gary. So what are things? Let's give tips here. What are things that an owner can do to avoid being sued by a manager?
Oh boy. How much time do we have? I mean, everything that we talked about. I mean, number one, recognize you've got to, and I know this is where the lawyers come in. I mean, I think this is a lot of the benefit that I bring, besides the legal, obviously the legal knowledge and expertise, is the objectivity. Is just, you've got to be able to think, to put yourself in the other person's shoes, just to understand where they're coming from and what buttons you want to push and what buttons you don't want to push to try to prevent these claims. A lot of times I will recommend, if we're terminating a resident manager and we want to buy and I know there are some skeletons in the closet in terms of how this person's been paid, okay, we want to do it in a way that's not sending them to Arie or some less reputable plaintiff's lawyer. And so I will often recommend, offer them a severance. Do whatever you, whether you want to give it to them, whether you think they've deserved it or earned it over the years, the goodwill, not just of the money. I mean, it's the approach and the attitude too, but the goodwill of just saying thank you for your hard work, it goes so far. Mm-hmm. I mean, I know that this is about resident managers. That's a life lesson, obviously, but I find it so true in this arena. So many of the resident managers, in part, what they want is to feel appreciated for all the hard work they've done. And even if you don't feel that they did a lot of hard work, which I often hear from owners, or even if you feel that their hard work wasn't very productive hard work, which I also hear, but bad job the resident manager did, they still worked. So show your appreciation, and keeping that relationship on that level will head off so many problems, and so often I don't see that. And so that's why they're in my office, because they're because they're getting a letter from a lawyer. But on the more technical legal side of things, make sure you do things right. And I realize the state of California does not make that easy on employers. I mean, not property owner employers, not business, no employer, but especially not property owner employers, because so many of the rules just don't fit the circumstances. The time record rules, the record keeping rules. It's such an odd fit, but you got to do it. I mean, for your protection, you have to do it. You have to insist on time records. You have to get time records. You have to maintain the time records. I hear so often from clients, I asked them for the time records, they just wouldn't do it. You know what the answer is? Then you got to get rid of them. Unless you're willing to take the risk that ultimately it's going to come back on your doorstep and that you're going to have a claim, and some plaintiff's lawyer is going to, you're going to get a demand letter for $300,000 going back 4 years for all the wages you didn't pay them because you thought they were working 20 hours a week, but they thought they were working 60 hours a week. If you want to take that risk, that's fine. You don't need the records then. But if you don't want that risk, then you got to follow through. And the answer is not keep asking. You keep asking, then you say, you know what, this isn't working out. I got to have the records. Pay the wage statements. Pay them right. And I know this is going to sound self-serving. This stuff is complicated. Come to a lawyer. Let a lawyer do it. Don't be penny wise, pound foolish. Because I see that a lot. I get a lot of, and I don't want to denigrate anyone's form contracts in this area, but many of them are not, some of them are passable, some of them are not passable. None of them, it seems to me, were drafted by employment lawyers. So even the ones that are passable are missing stuff and saying things they probably shouldn't be saying. So, do it right on the front end, and you will save, it's hard for me to measure how many problems I've saved, right? Because I don't know, but.
Well, I want to add to that, folks, to what Gary just said. If you get a letter from an attorney's office, plaintiff's counsel's office, don't give the letter to your HR director or to your accountant or your in-house counsel if your in-house counsel doesn't know diddly squat about employment law. Go to someone like Gary. You want to nip it in the butt in the beginning, at the inception of any dispute, because he's better suited to look at the problem globally and say, okay, these are the issues that you're looking at, to help you resolve your differences with the employee before it escalates any further. I see this happen all the time, where a property owner gets a letter from an attorney and gives it to an accountant. What the hell does an accountant know about anything about wage and hour and employment law? You're not doing yourself a service, because end of the day, that person is going to make a mistake, not take the claim seriously, and then the employee is going to end up filing a lawsuit. So it's always a good business decision. Most of you, thankfully, are doing well. Your business owners, make the right business decision. Give it to an employment attorney. Give it an employment defense attorney to fully screen you for potential employment claims. End of the day, you're going to save a lot of time and money.
I agree.
Yeah.
No, I think that's 100% right.
That happens all the time. They go to their accountant, they go to their HR director.
And if you're the HR director, please don't provide the plaintiff's lawyer with records and then come to me.
Oh.
Please come to me first, which I see also.
Yeah, we get occasional scores. I mean, they reveal more than they need to. And
Occasional scores.
I love it.
I like that.
That was True Nature came out finally at the end. There you go.
Yeah. Arie, Gary, thank you so much. I feel like we've all learned a lot today. I know I have, so.
Yeah.
It's been a pleasure.
thank you.
Well, great. And so again, Parker Milliken has sponsored this event. And Gary, thank you so much for coming up with the idea, putting it together. Again, they're LA, so you'll want to give them a call if you're out in this area. And you can draw up employment contracts for anywhere in the state, but
yeah,
is that right? Or how does that work? Okay, so that's good to know. Guys, really good stuff. Time records. The personnel file, you heard it over and over again. The agreement being done, being drawn up so that it's really specific to your industry, to the job that they're doing, and documenting everything. These are just basics, and then just the timing, right? And so I'm just kind of some of the key takeaways. I just want to repeat them again, just so that we're really catching those things. If you missed it, catch those things for sure. There's other things that I missed, obviously, but just to be really brief with that. But we're going to have, we also have another sponsor it's Livable, and we're going to go ahead and watch Livable right now.
Members, this is Daniel Sharabi, CEO of Livable. We've been partnered with AOA now for some years to bring our ratio utility billing services to membership. And what really sets us apart, aside from quality service and taking great care of your residents and billing them back fairly and accurately for their fair share of utilities, is that we have no minimums. So that means if you've got a duplex or a single family home with an ADU, we're happy to help facilitate the utility bill back on your behalf. So we would love for you to get in touch and join all of these happy customers in using our service and celebrating conservation, but also increasing your net operating income. Livable.com/AOA is where you can find more information and ways to get in touch with us. Look forward to getting some time scheduled and to telling you more about the program and how you can do your part to promote conservation. All the best and enjoy the live stream.
All right, great. Well, again, Livable, even if you're a small property owner and you own just a few units, they can still help you. So definitely look them up. Parker Milliken, again, just want to mention that our company AOA is also one of their clients because we bought a property management software company, and there's all these different consent forms when you're doing the online documents and also for the rent history reporting. And so again, they helped us with those different forms, those different agreements within our own program, because that's a digital thing and we're not used to digital. And so we're evolving as a company all the time. And then also just to mention, next week, again, if you missed it, we have Dennis Block, and he'll be addressing the tenant protections issues. And then at 1 o'clock, I believe, CA rent relief program. With that closing, that's the final day on this next Thursday. So again, we'll have Lori Blevins there, and she'll talk about that. And she's from within Housing is Key. And also, like all these different things, definitely subscribe to get on our email list for sure. It's free if you're on AOAUSA.com. If you scroll all the way down, you can put in your name, your email address, and also your zip code, and then we send you things when appropriate based on what's happening in your area. And then also some people, an update again, LA Superior Court, April 6th, we will have a hearing about the LA County lawsuit that we filed jointly with AGLA against LA County. And so just wanted to get those things out of the way real quickly. And we're going to head to the questions here. And so we have Tanya Richardson. For time records, can a worker provide their own timesheets, or do we employers need to provide them their timesheet?
I guess I'll take that one. Tanya, it really doesn't matter who provides the timesheet to the employee. It only matters ultimately that the employee fill them out correctly. Again, technically there's got to be clock in time, clock out time, and if they're entitled to meal breaks and hopefully are taking them when they clocked in for the meal break and out for the meal break. It has to have that information. Other than that, it can be crayon, it can be magic marker, it could be whatever. As long as that information is there, I think it's typically a good idea to have them sign it and that it's accurate, so you don't get into a fight later on. But it really doesn't matter who provides it. I mean, typically, if someone comes to me, let's say to do a resident manager agreement, I will give them a timesheet that I've prepared that I think is a little bit more suitable to use for a resident manager because it's got a lot of clock in and clock out times. But ultimately, you don't need to use my form or anyone else's form, as long as it has that information.
Great. All right, Hanson on YouTube. If I have a partnership interest in a building that is managed by the majority partner and they did not keep time records for the on-site manager, am I liable for the error?
Well,
He's smiling.
that's actually a good question, a very complicated question. We in Wage and Hour have what's called a joint employment liability theory, where, to answer your question, we have to define what an employer is. An employer is anyone who directly or indirectly controls an employee's wages, hours, or working conditions. So if any of these are relevant to the relationship, yes, you can potentially be liable. If you directly or indirectly control that employee's wages, hours, or working conditions. I don't know if you have anything to add to that.
No, the only thing I would add is the question doesn't say the nature of the partnership,
Right.
Whether it's a general partnership, a limited partnership, and that all of that information may bear on whether, as a partner, you may have potential liability of the partnership. So it's not an employment law question per se, but just a partnership issue.
That's why I defer to you, because the partnership stuff is outside the scope of my practice.
Okay, great. Christine, thanks guys for these questions. Christine, my resident manager asked her nephew to help her with work. She claims she paid him. Can I ask him to sign a waiver? And does the waiver legally protect me from being sued by the nephew later?
You want to answer that, Arie, or do you want me to?
Good, go for it.
All right, it's a complicated. It's not. There's no easy answer.
Yes.
Is the short question. The problem is, do you know about? All right, the resident manager is your employee. Now he or she, I think does it say she in the question, is asking her nephew to help. Is that nephew becoming your employee? Do you know that nephew is performing work on your behalf? That would be a key question that I would want to know. It sounds like you do. Did you know that before the fact? I can't tell from the question, but it's risky because if the nephew gets hurt, or if the nephew wasn't actually paid and sees a lawyer, you know that lawyer is going to come in and say that the nephew was your employee and was working for you. So it's definitely something you want to nip in the bud. In terms of getting a waiver, yeah, I mean, can you get a waiver? If you could try. That's the short answer. Will it protect you? Again, potentially, yeah, potentially no. It's hard for me to say. I don't know the language of the waiver. I don't know exactly what work was performed. I don't know what you knew about it. So there are a number of variables.
When you write up a contract, is something like that accounted for in an employment contract?
Yes. When I do an employment contract, So again, depending on the situation, I am often going to put in there that this is your job, it's yours alone, no one else, again, assuming I'm not dealing with a couple, no one else can do this job, you are the only employee. If it's a wife, part of a husband and wife team, and the husband's not being employed, again, I'm concerned about this risk. I'm concerned about the husband doing work and claiming he was employed, or vice versa. So I will put in the contract, you're the employee, your husband is not the employee, your husband does not work for us. So we want to cover that to the extent we can cover it and make it clear. Yeah.
Right. So you would write them up. You would document that if they were to come to you and say, "Hey, this person's doing work for me," that would be something to document and say, "Absolutely not. I do not authorize that," and don't do it again.
100%.
Right.
Okay. If you know about it, we want to account for it.
Right. All right. Eva, if a resident manager has their mother carry out cleaning duties on the property, can we reprimand the RM, oh, look at that, and require them to sign a formal agreement that they will stop this from happening again?
Not only can you should. Again, the risk, as I said, the risk is twofold in my view. The risk is the mom is going to get hurt and say she's an employee, and now you're into workers' comp issues. Or the risk is that she's going to be deemed an employee and you're going to owe her money. And I've seen both of those situations repeatedly. So yeah, absolutely. If you're aware of it, it is a potential liability for you, and you want to put a stop to it, including in the manner you suggested.
All right, great questions. All right, Tracy, if I hire a couple, can I have just one of them report hours for both and pay with one check, including those pay stubs, or do I need have both fill out forms to pay them individually?
Tracy, this is one of my favorite questions because it brings up a whole area. It's very interesting. So as it sounds like you may know this from the question, so there are certain laws about rent credit and how much rent credit you can provide, how much rent credit you can use towards wages to pay a resident manager. And there are different numbers set out depending on whether or not that person is individual or part of a couple management team. And that's all well and good, but all of those numbers are set out in something called a wage order. But the wage order is different from the labor code. And the labor code doesn't discuss a couple. There's no such entity in the labor code as a couple. It only talks about individual employees. So even though, and oddly enough that you're asking this question, I just litigated this very issue. And so where you have a couple, for purposes of how much rent credit you're applying, that doesn't mean you let me say it differently. You still have to treat them as individuals for all of the other labor code rules. And that means they each have to get paid. They each have to get wage statements at least twice a month. They each need to be paid at least twice a month. So for every other purpose, you're treating them as individual employees. And what often happens is one of the two does more of the work. And if you pay them equally, and this is the exact situation I just confronted, you're overpaying one, but you're underpaying the other. And the one that you don't get to defend the claim by the one that you underpaid by saying, but I overpaid your husband. It doesn't work that way. So hopefully that answers your question.
Wow, what a great question. Here we go. Michael, our on-site managers are required to clock in and out whenever they work through an app on their phone to keep track of their time. Do you see any problem with this for showing accurate records?
It depends. I mean, if the app, there are apps that record time in, time out. I mean, if you have an app that accurately records time in and time out, and this is maintained in, and in some format that it can be reproduced if and when you need it, and you are legally obligated to maintain it, then no, it's not necessarily a problem. I have seen cases. I have a case now where there is a complaint about the app that has been used, that it's not accurately recording, and certain changes can't be made to it. But assuming you don't have any of those issues, there's nothing wrong with necessarily using an app. One thing to keep in mind, though, if they're using an app or have to use the app on their cell phone, then they probably have, and we haven't really talked about this during the course of this session, but you are probably obligated to reimburse them, at least in part, for the use of their cell phone. You might have been obligated to do that anyway, even if they weren't using the app, if they were using their cell phone for the business. But certainly if you are requiring them to maintain their time on the app, then it is more likely than not you have to reimburse them at least some portion, the business use portion of that cell phone.
Great. All right, Facebook. Heather, does the labor board have any jurisdiction on a plaintiff's claim if they were not given a proper 1/3 rent credit?
You want me to? I'm happy to tackle that.
Yeah, go ahead.
You're all asking such good questions, all questions that I've dealt with in the last week, and I'm not making this up. The short answer is I don't know. When I'm on the defense side, I am arguing no, they don't. If I was sitting on the other side of the couch and I were Arie and I was in front of the labor board, labor commissioner, I'd be arguing, of course you do. It's not really clear, and the argument has been made to them that they don't have jurisdiction, and I don't know the right answer.
I believe the Labor Commissioner's Office does retain jurisdiction over those particular claims because at the end of the day, it's a wage claim.
Well, we can agree to disagree on that. Let me give you a perfect example, and I've had this. Let's say it's the owner who is collecting rent, but it is a management company that is employing the employee. If too much rent is charged, whose problem is that? Is that the management company's problem, or is that the owner's? Again, the management company has nothing to do with the rent being paid or charged. So it shows there is this dichotomy, and it's not clear to me, but ultimately it doesn't matter what I think, it matters what the labor hearing officer thinks, whether he or she thinks that they have jurisdiction.
I would just add both of them, let them figure it out.
I know you would.
All right, Christine, how effective is the attorney's fee cap clause?
Are you referring, I'm going to infer from the question, well, I don't know 100% what you mean. I know there's often attorney's fees cap clause in a rental agreement, and I don't know if that's what the question is intending. My view is if it's in a rental agreement, not. If you mean in an employment agreement, then again, employment agreements, when you have attorney's fees clauses, they have to be bilateral, they have to be mutual, whatever has to be good.
And reasonable.
Yeah, and reasonable. Whatever has to be good for the goose has to be good for the gander. But I don't see any, and Arie, you can tell me if you think differently, I don't see any reason why a cap, as long as it's going both ways, shouldn't be upheld.
Agree with you 100%. Yeah.
Great, thanks Christine for that one. Okay, Mike, Arie mentioned age as a problem. Please explain.
Sounds like a bunch of lawyers asking questions. So in California, there's what's called the Fair Employment and Housing Act, which has a number of categories of individuals that are protected. You're protected from discrimination on account of your sexual orientation, disability, medical condition, pregnancy, race, national origin, I don't know if I said religion, and also age. Anyone in the state of California over the age of 40, and it sounds ridiculous, but that's true.
It only sounds ridiculous when you hit that age.
Right.
You start to hit that age.
Anyone over the age of 40 in the state of California is entitled to protections of the Fair Employment and Housing Act. What does that mean? You can't discriminate someone on account of their age. You can't retaliate against them on account of their age. You can't harass them on account of their age. You can't treat them differently than younger workers. So most likely a 40-year-old resident manager is not going to have an issue with age discrimination, but some of the older managers might. And the case I was explaining to you folks earlier today, my client who was in his 60s had come to my office and said that the HR director told him that because of his advancing age, should consider retirement. For me, that raised a significant red flag there. Sorry, I keep looking at this one. Mike, so in that case, I declined the case because my client was engaging in theft, but if he didn't, I would have definitely filed the case because the timing of the comment and the termination, there was a causal link. That there was a comment made a week before about his age and he was terminated. So I would see that as an age-based discrimination case, and I would have filed it. It could also come in a form of harassment. They can harass you on account of your age. They can make inappropriate comments on account of your age. That needs to stop. And as an employer, if you have evidence of that, you need to nip it in the bud. You need to take proper measures to address the harassment or discrimination or retaliation, because as an employer, you could be liable for failure to correct harassment, discrimination, retaliation at work. So that's what the age-based protections entail in California.
Let me just kind of tag along with that and give the other perspective of that. I mean, everything Arie said is 100% accurate. It is a problem, maybe that's not the right word, it is an issue often when resident managers who have been in a building forever start, age, often to the point where, and sometimes the job, again, it depends on the tasks, of course, but sometimes the job is physically demanding. And often, someone who's been there a sufficient amount of time slows down and no longer can do the physical rigors of the job. And it puts the owner in a little bit of a tough spot. So it's true what Arie said, that you can't terminate someone just because they've gotten older. But it is also true that if they can no longer fulfill the core duties of the job, even without you giving them some kind of accommodation, then that would be legitimate grounds to terminate their employment. They just can't do it anymore. Yeah. So something to keep in mind, but obviously it's a delicate balance.
And we call that essential. You have to, as an employer, establish that the employee can no longer perform the essential functions of the job. I think that's what you're alluding to, right? Yeah.
Great. All right, Don in the chat, can a resident manager be paid salary only without recording hours potentially through the rent credit? Yeah, pretty clear. That's a definite no, right?
Absolutely not. There are two, without getting too complicated, there are two categories of employees in the state of California. You got salaried employees and exempt, non-exempt employees, which are paid by the hour. Unless you can establish that the resident manager fulfills or meets the criteria for being paid a salary, I would not encourage it, because one of the biggest cases that I have in terms of wage and hour are employees that are paid a fixed salary regardless of the number of hours that they work. The damages in cases like that are astronomical, especially if an employee is working a lot of overtime and perhaps some double time hours. So I would discourage you from doing that. Pay them by the hour, document their hours, issue wage statements that reflect their hours of employment, how many hours they worked, because it will become a problem.
I want to make a point, though. It was kind of an inference in the question, because the question specified if you're paying them with a rent credit. And I want to make something really clear, in case it's not clear. Paying someone with a rent credit is really no different, in a sense, than paying them with a check every month.
Yeah.
You're still paying them. And I know, because I hear from lay people a lot of the time where they don't consider, if they're just giving free rent, they don't consider that they're actually paying the person. You are paying the person. You're just doing it rather than paying them with a check or with direct deposit. You're paying them in the form of a rent credit, but it is still a payment. And so you got to remember that. So people say, well, do I have to give a wage statement even though I'm not really paying them? No, you are paying them. You're paying them with free rent, and yes, you still have to give them a wage statement. The wage statement will simply reflect that the payment was done through the form of a rent credit.
All right. Okay, Ellen, I am lost. Does the manager turn in his records in hours weekly, bi-monthly, monthly? How would the owner or management company keep the records of what the manager is doing? As example, to write off mileage, the mileage has to be recorded and have gas receipts to submit to IRS if audited. Bottom line, how and who is producing these records? Does the landlord's management company deduct taxes, etc., out of the 1099 forms at the end of the year?
All right, if we've done nothing else here today, we've lost Ellen, so we've accomplished something. Ellen, let me see if I can kind of walk through your question. So does so the answer is yes. The manager has to obviously the manager has to create the time records because only the manager knows what time he or she is keeping. But yes, the employer has to collect those time records. The employer, ideally, to do it properly, should be paying the manager based upon those time records. If the manager recorded 19 hours in a pay period, then that manager should be paid for 19 hours in that pay period. If they recorded 32, they're paid for 32, etc. On top of that, the law obligates the employer to maintain those records for several years. I think it's 3 years. It might be 4. I'm not. I think it's 3 years.
3 years.
Three.
So the first part of your question is, manager creates the records, but ultimately employer has to have them and maintain them. And then if there's some kind of dispute, it's the employer's obligation to have them and produce them, or the burden of proving the employee wrong shifts to the employer. So that's the first part of your question. Second part is really dealing with not so much with time records, but really with expense reimbursement. The employer ultimately must reimburse the employee for any business expenses that are necessarily incurred on behalf of the business. There's nothing wrong with an employer having a policy that says if you incur reimbursable expenses, you must submit to me those expenses as well as any necessary backup that I would need for tax purposes. There's nothing wrong with that. I guess the question becomes, what if you know, for example, cell phone's a good example. Cell phone is low-hanging fruit for plaintiffs' lawyers. So let's say you know the manager is using a cell phone for business purposes. You know that is a reimbursable expense. But the manager is not necessarily turning in receipts for the cell phone each month. I think the better course, the safer course, and the smarter course would still be to reimburse the manager for the use of the cell phone. But again, that doesn't mean you can't have a general policy that the employee or manager needs to submit for reimbursement. The last part of your question is about taxes, deducting taxes out of a 1099 form. If you're talking a 1099 form, then you're talking the wrong form. The manager, which should be clear by now, the manager must be treated as an employee. So you're talking about a W-2 employee. You're not talking about a 1099 independent contractor. But in terms of the thrust of your question, yeah, there may be withholdings and on the W-2 payments. It depends on whether or not you're using a rent credit or whether or not you're paying out of pocket. Out of pocket, there are it's like paying any other employee, and there are withholdings. If you're paying using a rent credit, it gets a little bit more complicated. There are no withholdings on the federal level. There are minimal withholdings on the state level. I'm not a tax lawyer. Talk to your tax accountant, but what I just told you, I believe, is generally accurate.
Great. All right, hopefully we got you unlost. Hopefully you're found now. Okay, and then there's Iwa. Oh, yeah, we want to go in order here, so let me go. Here's Rydal. What if a resident manager isn't earning the minimum rent credit monthly? What method do you recommend as best method to pay managers?
So if I'm understanding your question right, you're setting this up to pay the resident manager using a rent credit. Let's say, I'm just going to make up a number, this is not the right number. Let's say you're allowed up to $800 of rent credit to pay the manager in a given month. And if I'm understanding your question right, you're saying the manager isn't working $800 worth of hours. That's fine. Then what you should do ideally is set up the relationship so that you are paying up to $800 of rent credit each month. But the manager's still going to have to track his or her hours. You're still going to provide wage statements that, as a matter of law, I think Arie alluded to this before, needs to identify how many hours the manager worked each pay period and at what hourly rate. And then you're going to pay based on that. So if the manager worked 10 hours at $15 an hour, your wage statement is going to reflect a payment of $150 to that manager for that pay period, paid through a rent credit, and you should be good to go.
All right. And what we try to do with these questions, if this were the $1 million trade show that we put on, normally people would line up and you get to ask one question and then you go to the end of the line, and that way everybody gets a question answered. hopefully, if there's enough time. And then if you get a second question in, then that's just bonus material. So we'll skip Rydell's second question, and then we're going to go on to Riza's question on YouTube. If manager is salaried employee, does the employer still need to still record hours? So the salaried thing keeps coming up.
Salaried comes up all the time, and it really depends. You know, people use the term salaried loosely and in a non-legal sense, and Arie referred to it before. So a lot of times, in my experience, when people are referring to the terms salaried, what they really mean is you want to pay a flat amount per month. That's a salaried employee. But as Arie explained before, really in the law doesn't look at salaried versus non-salaried. The law looks at exempt employees versus non-exempt employees. Exempt means exempt from all the hourly requirements, exempt from the meal break requirements, exempt from overtime is really what it means. Whereas someone who's salaried is exempt. We equate those two, but they're not synonymous in the law. So we have to be very careful about the terminology. You should not be paying a resident manager who is by law an hourly non-exempt employee. You should not be paying that resident manager as if they are, number one, shouldn't be treating them as if they're exempt, because they're not, and you'll run into problems, and that person will go to Arie. And number two, even if that's not what you mean by the question, even if you mean you just want to pay a flat amount each month, but you are going to treat them as non-exempt, you're going to pay overtime if they incur overtime, etc., it's doable. It is not a good idea because the law is not set up like that. Pay records are not set up like that. Really, with a resident manager, you want to be treating them as non-exempt hourly and paying them based upon the hours they actually work. And if that's not the exact same amount each month, it's not. There are workarounds, because I know a lot of my clients say, I don't want to bother with that. I just want to pay them a flat amount each month. There are workarounds to do it in a way that still complies, but I got to tell you, it's really unwieldy. It's doable, but it's really unwieldy, and unless you have an actual payroll company managing it for you, and quite frankly, even if you do, it's going to cause all kinds of problems.
Great, and there's a question about rent credit. And one thing I do want to just cite the AOA magazine, just give a little plug for that. I know that you write articles regularly.
Yes.
And so at the bottom of this YouTube video, we're going to have one of your articles, like your most recent article that you've written. There's going to be a link to that for everyone watching. You can kind of see what he's written. And then also there's a treatment for this whole idea of the living on site and that rent credit and how much it is. The 2021 article really goes into depth, and so you'll want to look at that one. And then 2022 is good because it's the current numbers for this year, so those are two different things. But the question is here from Heather: if the owner lives on site, is there ever a need for a rent credit?
Heather, let me reframe your question a little bit. If the owner lives on site, you don't need a resident the law doesn't require you to have a resident manager at the building. Having said that, if the owner lives on site and you still have someone working at the building, you still need to pay that person, and you can pay that person in the form of a rent credit. The law allows that. But I'm not sure if this was the thrust of your question. You don't need an on-site person at the building if the owner lives there.
I wonder if they're paying themselves in that. I wonder if it's
not an employment question.
Yeah.
It's
Okay.
more of a-
Yeah, that's a good tax one. And here we go. What does a basic manager agreement cost to draft from your firm?
I would suggest, call me or email me, and I'm happy to discuss all of that stuff with you offline.
All right. Okay. Well, there we have it. Guys, thank you so much for watching this video with us or participating with us. And hope that you got a lot out of it. And one thing, there's so much here that's so key. You have to share this with your friends who also own rental property. So share it and give it a like. If you like what they put together, give it a like. And that also helps it get out there a little bit. We're not doing anything with Google or YouTube to make money off of this, but just the more people that hear about it, this is good. It's good for everybody. It's good for the whole industry. So definitely want to ask for you to give it a like. And just remember, next week we have Dennis Block speaking about LA specifically, and he will address state as well, but LA specifically, what's going on. And with the housing is key, the window is closing. So whether your tenant would qualify or not, if somebody owes you money, you need to apply for with housing is key before the 31st. Do it, please, 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 just to close the door on any of not being able to get back what is owed to you. Please do it. You have till the end of the month, and then again, everything is changing, and that's why Dennis is coming to speak. That's why we have someone from Housing is Key coming to speak as well. And we want to keep you in the know. Housing is Key is for everybody across the whole state, as you guys know already. And so we'll look forward to seeing you next week. And also, just go on you may be watching this live, and maybe you don't realize that we have tons of videos. They're all on YouTube. So if you type in AOA USA, you'll see that we have a whole channel. You can go there, and then specifically you'll see what we have, and you can just binge watch if you want. And anyway, again, thank you everyone, and thank you Arie, thank you Gary, and for Andrea for your time with us today, and we'll see you next week.
Thank you.
Thank you.